Once one party files for divorce in New York, what is generally the process or timeline if the divorce is contested?
The divorce case does not necessarily become contested immediately. Usually the courts encourage the parties to negotiate a settlement first. Now, there's some cases where I would advise a client, don't even bother if they tell me I don't think that there's any realistic chance that the other side will agree to what I'm requesting. For instance, if I get retained by a client and they say, well, I know I want sole custody and I'm not willing to negotiate anything other than sole custody. And I know for a fact that the other side is never going to consent to sole custody. Then my advice to that client is don't bother waiting around for anything. Just file your request for judicial intervention. And that's a long way of saying I want a judge assigned to the case, and get a preliminary conference scheduled. If it's not that situation, if in other words, the parties say, I think that there's a shot to work out a settlement, then the courts will, by rule, give them up to 120 days, a long way of saying 4 months, to negotiate a settlement. After that period is reached, and that's 4 months from when the answer is served, then the courts say you should file for a preliminary conference if you're not either settled or darn close to it. Now, that's kind of a soft rule with the courts. There's rarely any consequences to someone not filing a request for judicial intervention at the 120-day mark. But I always let my clients know they should file. If you're not settled at that point or darn close to it, you're probably not going to settle. And you should probably proceed to file for that PC at that point.